fact of this separation on her, you were allowed only to ask questions to me, um, and I will be glad to provide answers. We will make available the recording to everyone who attended at the end of this. And I respect everyone's time. We're going to make this really short because Ms. Smith has to go back to work. Mr. Seamus Culleton has been in custody of the Immigration and Customs Enforcement since September 9 of 2025. Culleton came to the United States as a visa waiver program entrant in March of 2009. This program essentially allows participants to stay in the United States up to 90-day period, after which they're expected to depart. Culleton overstayed the 90-day period of his authorized stay in the United States. Another additional requirement of the visa waiver program is the fact that participants also waive their right to contest any attempts by the government to remove them from the United States, except for when they have a claim for asylum, which then takes them before an immigration judge. So essentially, he would not have a right to go before an immigration judge but for a claim for asylum, which he does not have. So visa waiver entrants are not subject to the usual removal process where non-US citizens appear before an immigration judge to contest their removal. Rather, they have a separate administrative removal process where the process of their removal for any visa violation is effected and consummated only by the Department of Homeland Security officials as well as ICE officers, except for the asylum claim that we talked about. I'm going to admit more people. This summary administrative removal process then mandates the government to follow specific rules etched in efficiency and fairness. For instance, participants, VWP entrants, are mandated to receive notices by the government of their intent to remove them from the United States, as well as certain other procedural protection. So I want to make it clear to everyone that historically, the government of the United States has given preference to immediate relatives of US citizens, as well as statutorily in our immigration and nationality laws. Immediate relatives of US citizens, people who are married to US citizens and who have submitted a petition for a green card, usually get exemptions. They are forgiven for certain immigration violations related to visa overstay or working without your employment authorization. Furthermore, the USCIS has policy memos which suggests a strong preference and encourages both the USCIS to adjudicate petitions for immediate relatives of US citizens and allow them to adjust status even in a situation where they overstayed their visas as visa waiver entrants. So essentially, it is a discretionary power and authority that the government has. And historically, they've exercised that favorably as long as I've practiced immigration law, 22 plus years. So it's a discretionary issue for the DHS and ICE, and they've historically granted a favorable discretion in cases like Culleton's, who has a marriage-based adjustment of status application pending before the USCIS and pending before he was picked up by ICE. Culleton has been in the United States for almost 2 decades. He has established a life in the United States, opened up a small construction business, a plastering business. He's made significant contributions to his local community in Woburn. He has strong familial and community ties to Massachusetts. He has no criminal entry in his record since coming to the United States. He's married to a US citizen, Tiffany, and Tiffany petitioned the US government, and Seamus, Mr. Culleton, also submitted his green card application prior to his arrest by ICE. I would also note that USCIS, which is the arm of immigration that processes forms, had already started processing his green card application, leading to the grant of his employment authorization status. Culleton does not have a claim for asylum, the reason why there's nothing going on before an immigration judge. At the time of his arrest, in September 9th of 2019, Culleton informed ICE about his pending green card application and alien relative petition that was pending. It didn't make any difference. Culleton was also scheduled for his marriage-based green card interview in November. That one was rescheduled again to December of 2025. Requests to the USCIS to allow him to attend the interview telephonically were also denied. After his arrest in Massachusetts, Culleton was initially moved to Burlington and then to Batavia, New York ICE facility, and from there to his current location in El Paso, East Montana camp in El Paso, Texas, where he's been for over 4 months. I want to also explain that a habeas petition was previously filed before the U.S. District Court for the Western District in El Paso, challenging the unlawfulness of his detention without notice, as well as certain due process violations in the case. The petition was denied by the court on January 23rd of 2026. The court reiterated that visa waiver program entrants under the Fifth Circuit precedent waived their due process rights by entering as a visa waiver entrant. And so, the Fifth Circuit is different from other circuits. There's a reason they are rushed from a circuit like Massachusetts First Circuit to a circuit like Fifth Circuit. There were other issues raised in the case relative to the notice requirement under the visa waiver protocols that the government has to comply with, as well as a big issue made about the signature in the case, that signature on certain documents, multiple documents that Mr. Culleton denied signing. The court ruled in the government's favor, despite citing multiple procedural irregularities by the government in the case. The judge had said that Culleton testified he had not slept in days due to the conditions of his detention, and those circumstances might have affected his memory. Today, Culleton is still in ICE detention under extremely dire conditions, as he had previously mentioned in the interview that is circulating and instigating all of these reactions. He is in danger of being removed from the United States any day now. What we're seeking by calling this news conference is we're asking for his immediate release so that he can complete the process of adjusting his status to that of a lawful permanent resident of the United States, a process that's already started and a process that might be consummated if he is released from custody today. We ask that the Department of Homeland Security, as well as Immigration and Customs Enforcement, rescind the administrative order of removal that they served on him in November 14, 2025, and allow Mr. Culleton the opportunity to reunite with his wife and family. He is not an enforcement priority. He is not a danger to personal property. He is married to a U.S. citizen. Thank you. And I will just turn it over to Tiffany Smith for Tiffany to give her statement, and then I can open it up for questions. Tiffany.
Hi. Hi, can you hear me?
We can hear you perfectly, yes.
Okay. Hi, I'm Tiffany Smith. I'm a U.S. citizen. I've lived here my whole life in the Boston area. This whole thing has just been so overwhelming. Life has just been on hold for the past 5 months. And I want Seamus home where he belongs. I want us to be able to finish what we started. And I just want him home. I want him safe. Seamus is a good man. He doesn't deserve what is going on. And it's heartbreaking. It's absolutely heartbreaking. I don't know how I've gone on these last 5 months, to be honest. It's been awful, and I don't wish this upon anybody.
Thank you, Tiffany. And I will open it up for questions. And let me just state that Tiffany has to leave by 1:30, and so we're going to shut down by 1:30. And I thank you for your understanding.
Hello, can you hear me?
Yes.
Hi, Gavin O'Callaghan is my name. I'm from RTE News here in Dublin. I just have one question really is about Mr. Culleton. Did he have any previous interactions at all with law enforcement, either in the US or in Ireland, prior to his detention by ICE?
What was your name, sir? I want to make sure that I got your
Uh,
name.
Gavin O'Callaghan is my
Calvin,
name.
thank you. Thank you. So today, I think it was your station that spoke about a warrant 20 years ago in Ireland. This is the first time that we're hearing about that. So to your question, I can't speak to a warrant. Your station also mentioned that it was April of 2009. Mr. Culleton has been in the United States since March of 2009 and will not be aware of any warrant that happened after he came to the United States. So warrant is not a conviction. Warrant is not a criminal entry. So I will leave it at that until I understand the specific facts of the case. Thank you. Next.
Thank you.
Hello, my name is David Beanick from Channel 5. Can you hear me?
I can hear you well, David. Thank you.
Can you please describe the circumstances surrounding his detention last September? Where was he? What was he doing? And why do you think ICE targeted him on that specific day?
Thank you, David. To my understanding, he was returning some items. He owned a small business, small plastering business. He was returning some items at the Home Depot located in Massachusetts. And it just happened to be there. ICE would frequently be around such business, such businesses, just, Supreme Court decision gives them the authority to, pave around places like that. Non-US citizens do some kind of works that will make them be around the Home Depot. So he happened to be wrong place, wrong time. That's how, that's what we know from the record.
Can you specify which Home Depot was it? Was it the one in Saugus?
Route one in Saugus. Yes,
and
David.
so how did they identify him as someone with a questionable legal status?
I believe they also ran his license plate. That was also in one of the 213 documents that the government provided. They should be able to know if someone is a non-US citizen if they run the license plate.
Hi, this is Sophie Alexander. I'm with Bloomberg News. We've been covering the detention expansion, and I'm hoping to understand before he ended up at Camp East Montana, whether he was in other detention facilities. And I'm also curious about your access, the access he has to his legal counsel and communications around that while he's been at Camp East Montana.
Thank you, Sophie. Ms. Sophia, yes, Mr. Culleton was transferred to Batavia, New York, where he stayed for, I think, approximately a week and change before. So Burlington, Massachusetts, Batavia, New York, and ultimately East Montana, El Paso. And we do have access to him as his attorney. I'm able to schedule calls with him.
Have they given you any explanation as to why they've transferred him so many times?
Okay, Sophie, transferring people through ICE is the norm. They don't give you any explanation. They are allowed, or they typically or frequently transfer people from one place to the other. Our wish as attorneys is that our client stays within the jurisdiction of where they live, but we don't get that wish. No one gives you an explanation of that. Anyone else have any questions?
Hi there. It's Gareth McNamee here from the Irish Daily Mail. I hope you're well today. I wanted just to echo another my colleague there who was speaking in relation to the pending drug charges, but the charges which Mr. Culleton was facing in Ireland before he left for the USA. Now we've managed to confirm that there was 3 specific charges pending against him at the time before he came to the United States. I'd like you to speak on that if you could.
I don't know if you listened to my initial response to that question. Your colleague already asked that question.
Yeah.
I said it's a warrant that issued after he came to the United States. I cannot speak further without knowing the details of the case.
So you're not
Also,
aware of it. You weren't aware
said,
of it, no? Were you not aware
no,
of it?
we're not aware of that. We don't know. Today is the first day that I'm aware of anything like that. And like I said, a warrant does not equal a criminal conviction. A warrant does not equal, so none of those. So until I
Yes.
can't, correct. I can't speak more on something that I don't know about.
I totally understand. And have you spoken to Mr. Culleton about
No,
that?
I
That
have
answer
not.
no is okay.
I have not spoken to him since this broke today. No.
Of course. Thank you very much for your time.
You're welcome.
Hi, I'm Molly Farrar with Boston.com. Can you hear me?
I can hear you well, Molly. Thank you.
Great, thank you. So I'm wondering, because he's been in detention for 5 months. I'm wondering, why is he still in detention? Is there a removal proceeding coming up? Like, what's scheduled for him next legally? And in addition, I know there's been some reporting on the conditions. I was wondering if you could talk a little bit about what it's like for him right now in detention.
Thank you, Molly. Molly, so the visa waiver program entrant is not typically placed in removal proceeding. It has a separate administrative summary process that typically does not involve the immigration courts. So that process is bypassed. It's a separate administrative process that essentially involves DHS and ICE. And like I mentioned while I was reading out the statement, I said when you enter as a visa waiver entrant, there's an implicit waiver of essentially your right to removal proceedings, where you get to contest the removability or the basis of your removability, unless you have a claim for asylum, which he did not have. So it's a summary process that is also that also requires due process. The process for the administrative removal is in INA 237. It requires efficiency and also fairness. And I said, and I need to stress this, that historically and statutorily, immediate relatives of U.S. citizens get that exemption. The fact that they overstayed the visa, which is the lone charge in this case, is not an impediment for them to get the green card, and it's done all the time. Policy memos from the USCIS supports adjudication of the green card petition filed by a U.S. citizen wife, irrespective of the fact that the VWP entrant overstayed their visa. As to the condition of the detention, I think pretty much the whole world is aware, cognizant of the interview that he gave, where he explicitly describes, what his conditions are. It's not good. I saw him 2 weeks ago while I was up in El Paso arguing the habeas petition, and he did not look well. He looked like he probably have lost about 30, 40 pounds. He looked yellow, like someone who was jaundiced, and he also explained that he looked like that because he's barely let out. In that time, it was about 4 months. He said in 4 months, he's not sure. He's had up to 4 hours of whatchamacallit, of sunlight. Thank you. Anyone else has a question?
Hi, this is Anna Catherine Bridget. I'm with the Associated Press. I was wondering if you can elaborate a little bit more on that habeas petition and the result of it, and whether you think that he was given a fair process. And also, what are the since you are still requesting his release, what is the legal recourse now that has been denied?
Thank you, Anna. That's a great question. The habeas petition originally challenged the unlawfulness of his detention. The basis of its unlawfulness was due process violations. He sat in custody from September 9, 2025 up until November 14, when he got the first ever paperwork, right? So he was held without any notice, a fundamental constitutional violation. So we essentially filed the habeas challenging the just you're holding someone with no charge, as well as the fact that the government did not follow the rules. And when we filed that petition, the government responds with a bunch of documents showing his signatures that predated um, we try. So just I'm going to step back a little bit. The government gave him the option to seek bond before an immigration judge, even though he was not entitled to bond, because, like I explained, VWP process, you bypass that. We sought bond before the before the El Paso Immigration Court, and bond was granted in the amount of $4,000. Tiffany posted bond, and the next day the government files a motion asking the judge to rescind the bond that was entered, and for the first time raised the jurisdictional argument, saying that the judge did not have jurisdiction under the clear language of the Visa Waiver Program, INA 237. The judge agreed that it lacked jurisdiction, and so rescinded the bond in the case. So also during that particular hearing, the government conceded that no notices had been served on him. So this was in October. So now imagine the surprise when we filed the habeas petition in November. The government brings up so many paperworks for the first time in the habeas petition, purporting to be documents served on him, and some of which had signatures that Mr. Culleton denied ever signing or ever seeing the documents. So that's why I explained that the judge also, in making the determination, so the judge ruled Visa Waiver Program entrance, you waive your rights to even due process. Well, that's not the law here in the First Circuit, but there's a reason he's in the Fifth Circuit. So the judge ruled, number one, you're not entitled to due process. So the due process arguments were essentially shut down. And number two, I believe that you were served with the notices, even though in October, during the pendency of the bond hearing, that was eventually rescinded, the government conceded that they had not served any papers. So that's essentially what it is. Do I believe it's fair? Of course, I believe my client when he said that he never saw nor signed any of those documents. I was not happy with the judgment, but my client is located in that circuit. So what are the options? We're exploring, legally speaking, we're exploring doing another habeas and bringing up other issues, maybe doing it in a different circuit. It's all up in the air. But the biggest ask and the biggest thing I want to come out of this is essentially what Tiffany wants, which is everyone ask ICE and the Department of Homeland Security to rescind the order of removal, because historically they've done that in essentially the situation as this one, where there's an immediate relative exception and where there's no allegation that the person is a flight risk, danger, criminal, a criminal of any sort and all of that. He's just the perfect candidate to have the government exercise a favorable discretion on his behalf and allow him. So it's about rescission of the administrative order of removal, which was served on him on November 14th of last year. I hope that answered your question, Anna.
Hi there. Can you hear me?
Yes.
Hi, this is Daniel Coates. I'm a reporter with Boston 25. I wanted to just see if you could expand a little bit more on the timing and the context of him getting his green card. He had been in the country for around 20 years. Why was he just now in the process of getting that green card?
Thank you, Daniel. I get that question all the time from people who are not in the immigration space. But so he fell in love when he fell in love with Tiffany. There's no answer to that besides the fact that he fell in love with Tiffany in 2001 or 2002, and the process took the logical next step. They got married and they started the process. So, and for people who don't understand what immigration law looks like, these processes can take years. However, their process did not take any years, because within a couple of months after they submitted their application, they got their employment authorization, which is anchored on the green card application. They got that they got that approved, and they were scheduled for the green card interview. So the government can, if the government lets them, if ICE releases him, he can practically walk into the USCIS office in Boston and get interviewed for his green card and get it. So my whole argument is, if we're all about family unity, if we're all about a humane approach to immigration, if we're all about getting out the bad guys, why is the government not exercising a favor and allowing him? It's the same government that schedules his interview twice. That's the same government holding him and depriving him of the right to attend those interviews twice. So we had a first interview date in November and another interview date in December, and he's still there. The same, just separate USCIS schedules the interview, and ICE still is holding him.
So that green card process. Yeah,
we have
okay.
4 minutes, Daniel. So I will be getting off soon. 4 minutes. Yes, Daniel.
Hi, this is Patrick Madden at WBUR. Because I know Tiffany has to run. Can Tiffany speak about her last conversation with Seamus and what she's learned and what he said?
Tiffany, go ahead.
Yeah, I spoke to Seamus this morning. We have normal conversations. He asked me about my day. He tells me to have a good day at work. I'm just trying to stay positive for him. Everything is very overwhelming for the both of us right now. So we're both just trying to stay positive.
And just, can you reiterate what Ogor was saying about what you're hoping for here?
Yeah, of course. I hope Seamus can get released. I hope he can come home and we can finish what we started. We tried to do everything the right way that you're supposed to do. So I'm just begging, just let us at least finish that.
Thank you, Tiffany. And we'll get one more question till we close.
Thank you. If it's possible, would I be able to get a date of birth for Mr. Culleton, if that's okay?
Say that. Sorry, I didn't hear you well, sir.
If it's possible, would I be able to get a date of birth for Mr. Culleton, his age?
Oh, he's 38 years old.
Thank you. And would it be possible to get a date of birth?
I will not be able to do that publicly in a public setting, no, sir.
Good try.
Thank you.
Thank you. Garrett,
Can you please say if Tiffany plans to follow Mr. Culleton back to Ireland if he is deported? Can she move there legally, and does she desire to do that if that becomes necessary?
I think that's a conversation for me and Seamus to have.
And I can tell you from speaking to both Tiffany and Seamus, their goal is so Seamus has made a life in the United States for over 2 decades. Tiffany was born here in the United States. They have a business, they have family, they have everything here. And, people think it's easy to pack up and go. It's not easy when you've made a life somewhere and you've tried to do everything right, and you just pack and go. And I always just say it's not just Tiffany and Seamus that are impacted by a separation. It's whole communities that are decimated. And who does it benefit? I always ask myself that question: who does it benefit? What's the public benefit to having people detained forever, like prolonged detention? Who benefits from it? So these are significant questions that we should be asking ourselves as a community. Who in fact benefits from people being detained for so long? I can say that it's none of us on this call that benefits from it. And so, ladies and gentlemen, I thank you for your time. Our office is going to try to make available the statement that I read out to you as the official statement coming out of this of this office on behalf of Mr. Culleton. Thank you so much. Okay, bye. Thank you.